All right, we are here, and I am just pleased, and we are all blessed by being in the presence and having Attorney Kelley Henry here with us. For all who don't know right now, she is the lawyer representing Purvis Payne, who, as you know, is set to be executed December 3rd. He has maintained his innocence for 30 plus years, that he did not do the crime, and he has kept saying that over and over. And as we learned on last week, the story that he has told over and over for over 30 years has not wavered at all. And I am, again, so blessed and so honored to have Attorney Kelley Henry here. So Attorney Henry, welcome to G Life and welcome to our conversation roundtable.
Thank you very much. I'm pleased to be here.
Well, first of all, you know that Gifts of Life Ministries, as well as the G Life Social Justice and Public Advocacy Ministry, has taken an interest in this case. And you know that we are on the street corner. Matter of fact, we're just coming back from being at the corner of Union and McLean every Wednesday at 4 o'clock from 4 to 5, bearing witness and trying to bring attention to this case. But before I get to the case, we just want to, since this is a conversation with G Life, why don't you let our hearers and viewers, in a little bit something about you. Talk to us about your journey as an attorney and how you got to this place, and how did you even come to represent Brother Payne?
Well, thank you so much. And again, we are so grateful for you and for G Life Ministries taking an interest in Purvis's case. And I really am just appreciative of this opportunity. The way I got into this work is, actually it started with an 8th grade history class.
Wow.
Where I was failing history. And, I'm the first one in my class in my family to go to college. And I didn't really know what I was going to do with my life. And I got pegged to be the defense attorney in this mock trial that we had to do in class. And I just really got into it. I just loved every aspect of that. Ended up having my client acquitted by the jury. And at that point, that teacher made a difference in my life, and I knew what I wanted to do. And so I went to law school and immediately got a mentor.
Where did you go to law school?
I'm sorry?
Where did you go to law school, if you don't mind?
So, well, I'm going to date myself now. I started law school in 1988. Oh. So, actually, when Purvis was, that summer where he was going, was tried, and he's just a year younger than me, I was preparing to go to law school. And in fact, that summer I had been working at the public defender's office. So, so I went to law school in Kansas City, which is where I'm from.
Okay.
And I was fortunate enough through a mentorship program to be paired with a man named Sean O'Brien, who is somebody who's been doing death penalty litigation. At that point, he'd been doing it for 15 years more than me, but he seemed a lot older. I was his first law clerk at what was called the Missouri Capital Punishment Resource Center. And I just knew when I started working on those cases, and when I started going down to death row, which was in Missouri, is in Potosi, that was my calling. It was just what I needed to do. It wasn't to make a lot of money, and I certainly couldn't prosecute. So that's how I got started in the work. And I represented my first client, who I represented on death row, was a man named Leonard Laws, who was executed in 1989. We represented him for the last month of his life. And that experience, I woke up the next morning and I said, you can either lay down or you can get back up and fight. And I got back up and fought. And that's what I've been doing ever since. I was lucky enough to come to Tennessee in 2000. I was hired on at the Federal Public Defender's Office in Nashville. And I work in a unit which I actually supervise, where we only represent men and women who are on death row. And our primary responsibility is for Middle Tennessee and West Tennessee. The West Tennessee Federal Public Defender at the time did not have any lawyers who were qualified to handle capital habeas cases. And just historically over time, my office has continued to be invited over to Memphis to represent these clients. So I've been there for 20 years. I came to Tennessee exactly 1 month before Robert Coe was executed.
Wow.
My unit has 8 other lawyers besides myself. And like I said, I'm the supervisor. We have investigators, paralegals, and legal assistants.
Mm-hmm.
I did not come to be Purvis's attorney. He had other counsel until last October. And in last October, because his previous counsel had gone on to do other things, I took over the case and assigned our team, and we began to investigate the case. And I investigated it the way I investigate all my cases, which is because I was a trial attorney, I look at the case, I look at the police records, and I say to myself, how would I investigated this? What looks wrong to me? Who do I think is lying? And then we set about our course of investigation. And I'd known Purvis for 20 years because he's the porter at Unit 2. So I would see him, I'd say hi to him. He took care of one of my clients, Charles Wright, in the final days of his life before Charles succumbed to cancer. So I knew him, but I didn't know his story. And I didn't know his family, and I didn't know his family story. And as soon as, my team and I got into his case, we immediately recognized that he didn't do this, right? And that because of his intellectual disability and because of the systemic racism, which we know exists in the criminal justice system, or the criminal legal system, because there's not a lot of justice to it.
Well, Bill Barr said it doesn't. Just our Attorney General now says systemic racism is not an issue. But go ahead. I'm sorry.
Let me say that Bill Barr's never represented a client.
Right.
This case is really, I consider myself, a hardcore, public defender, dyed-in-the-wool, liberal. But this case has challenged me to look at my own bias and to look at the bias of my colleagues. Maybe it's the time as well that we're finally willing to say, oh, but I'm a good person, so I can't be a racist. And having, implicit bias doesn't necessarily mean you're a bad person, but it does mean you're a product of, all of your life experiences. And, Purvis's family has been ignored and marginalized throughout this entire journey for them. And they've been in prison with him this entire time. And, I think his mother, that as a mom of 2 boys, 19 and 22, my heart breaks for her. I never got to meet her, and I am worse off as a person because I didn't. But to think about how that woman did everything that a mother is supposed to do. Mm-hmm. This family did everything that our society asks of a family. Elder Payne, hardworking man, a man of God, raised their children, built his house, with his own hands, had a successful small business. Mrs. Payne was a child care provider. They raised their kids to know right from wrong. And they raised them with love. Yes. And still, the system stole their child from them and didn't listen to them. And when she was there that night at the police station, and she was saying, take his blood. If you think he did this, take his blood. I want to know if he's on drugs. And they refused to do that because they dismissed her, because they didn't give her the same respect that they would have given me. Mm. And that breaks my heart. And that is why I do what I do. I want to fight for Mrs. Payne. I want to fight for Rolanda. I want to fight for Elder Payne because I can, right? God gave me a certain skill set. There's not a lot I can do. I can't make you a really great pie, but I can fight. And I know the law.
All right. That's and that is what's needed. And that's what we try to tell everybody, when everybody's talking about, I don't know what I'm going to do or what shall I do? No, you need to do what you are good at. If you know what you're good at and you can contribute, you go and contribute that. But can I just go back to something you said earlier about West Tennessee again? I think I wrote this down. You said there are still today, no one, we said lawyers that are not qualified to handle habeas and capital cases?
Yes, so
But,
in order, the work
okay,
I do is pretty specialized.
right.
I'm sorry?
No, go ahead. No, yeah. Just unpack
So,
that a little bit for us.
So when we talk about habeas cases, that's actually, we know that from the Constitution, right? The writ of habeas corpus shall not be suspended.
Mm-hmm.
And the way that is protected in federal court is under a statute called 28 USC 2254. And it is under that statute that I come to represent my clients. So
Mm-hmm.
they have gone through the state system and they come into the federal system with, a stamp of approval on their conviction and sentence. And then it's my job and my team's job to look at everything else anew because that's their right under the statute. So to do the work that I do, which is called habeas corpus, so I'm in what's called the capital habeas corpus unit.
Mm-hmm.
There are only 22 of those units in the entire country. Tennessee has 2. We have one in Knoxville and one in Nashville.
Okay.
But in order to do that, it takes a certain skill set. And the public defender's office, the federal defender's office in Memphis at the time, didn't have a capital habeas unit. And quite frankly, most of the cases come out of West Tennessee. Over half of death row is from West Tennessee, particularly Shelby County.
That's why I asked, because I knew that statistic. You would think, well, anyway, I don't know. I'm just like, like you said, over half. I mentioned that on last week when I was talking about this case, over half, 50%, if you just think about that. And just somebody who would just come from another planet and just look at the numbers, they would even think, oh, either one or two things, either something is going, either the A, that, oh, all the bad people somehow are moved here, or B, that something is kind of wrong with this system. But no, that's what I was getting at. You would think that would have been maybe located in Memphis or in Shelby County. But anyway, I get it.
Well, there's a political price to be paid in Shelby County if you go up against the system, So sometimes you have to be from the outside.
Oh, yeah, that's true too. Yep. And I know that also well. So since we're talking a little bit about the case, let's talk a little bit more about the case. So tell our viewers, okay, what is this case all about?
This case is about a 20-year-old intellectually disabled young man who came across a crime scene and tried to help and then realized that as a Black man standing over a white woman who had just been killed, that there was no way but that he was going to be seen as a suspect, and his worst nightmare came true. This is a case of a man who should never have been put on death row to begin with. I mean, just death penalty just off to the side. He shouldn't even be subjected to it because of his intellectual disability. But it's also a case of an innocent man who has been wrongfully convicted by a system that is systemically racist.
So when you first looked at the case, can you just share with us, without going into too much detail, because I know you're still working on, of course, on the case and working on other things about the case. But when you first looked at the case itself, and when earlier you said you do it just like any other case, you investigate, see who's telling the truth, who's lying, all of that, what immediately jumped out at you that made you say, oh my God, what is this? What's going on here?
So there's a number of things, but let's just start with, since I've been doing this work for 30 years, I've represented people who are guilty of some pretty bad crimes, right? And most of the time, if I'm looking at a case, often I'm looking not at who done it, but why they did it. And, in those cases, I'm going to see history of severe mental illness. I'm going to see trauma. I'm going to see sexual abuse. And I didn't see any of that here. Purvis is not the sort of person who would have a motive to commit this crime. He didn't have any history of violence before or after. Now, that's pretty remarkable. Now, we know that mental illness can have its age of onset in 18, 19, 20 years old, but then you would expect it to continue on, for there to be additional symptoms. Mm-hmm. No symptoms in his case, none. So number one, no motive. His character just not in line with someone who would commit this crime, mm-hmm. right? Mm-hmm. This isn't a robbery gone bad. This, kids can, find themselves in bad situations, but not this crime, not this one. Mm-hmm. You're going to see something more dramatic in the individual's background. But the second thing that just really stuck out to me in reading the case, the police officer who was one of the state's star witnesses at trial, we know that Purvis, rushed past this police officer as he ran from the scene because he was afraid. Mm-hmm. And this police officer testified that Purvis said to him, "I'm the complainant." And he said that was a direct quote. That's just not believable. People don't talk like that. Right. Kids don't talk. Normal people don't talk like that. I wouldn't talk like that. A 20-year-old kid with intellectual disability is not going to say, "I'm the complainant," right? Mm. And what's important about that is, if he's lying about that, what else is he lying about? Because we know he's lying about that. Mm-hmm. And this is the police officer who allegedly found what became the centerpiece of the concocted sexual motive, which is 2 days after, not the time of the crime scene or of the murder, but 2 days after, he allegedly finds a bloody tampon on the floor. He claims in the kitchen near where the victim's body would have been, that they somehow missed when they were processing the crime scene. Mm-hmm. Now, again, that's just not believable. Mm-hmm. You don't miss a piece of item of evidence like that when you're processing the crime scene. Mm-hmm. It's not in the photographs. It's not in the crime scene video. So again, okay, well, now we're lying about that. Mm-hmm. And, I don't know why they're lying about it. I don't know what they thought they were going to prove with it, except they tried to suggest that indicated some sort of sexual activity took place. They claim in the trial, when you read the opinion, they claim the victim's clothing was a miss. It wasn't. She was wearing a very short romper, and it was not a miss. Mm-hmm. It was completely intact. Mm-hmm. And then you look and you say, well, wait a minute. Where are the victim's clothing? Where are the photographs of that? Where are they? Right? I mean, you think this is a sexual motive. Where's her clothes? Mm-hmm. They've disappeared. Mm. We don't know where they are. To this day, we don't know where they are. Then they say, well, we had some color photographs, but the only way we could take color photos is because our chief was the only one who had a color camera. And, well, when we went to develop the film, we realized that we didn't have any film in the camera. Again, that's not believable. I mean, again, I've dated myself, right? So I remember what those cameras used to be like, and you would have to, forward it, right? Yes. And it would tell you how many, pictures you had left on the roll. So it's just not believable. Where's that roll of film or rolls of film? Yeah. So that jumped out at me right away. Just all of these things that just didn't make sense.
And you're going through this, and I just cannot help but to think about, I mean, if I wasn't in it, and if I wasn't really knowledgeable of, because I remember the case back in '88. I remember what happened. I believe, was this the first case? I believe the first case that the Supreme Court allowed impact statements to be allowed in. I mean, somehow the Supreme Court got involved in this case and did something as it relates to impact statements and stuff. So people, even what you are just sharing with me right now, sharing with us right now, and I'm thinking about those statements and I'm thinking about everything. if I didn't know any better, this sounds like a movie. This is like those documentaries that you see that, you know, that surely could not take place. But, you know, here we are. And so last Wednesday, Judge Paula Scan ordered some DNA testing. Can you talk a little bit about that? I know the week before we were pressing test the DNA, hashtag test the DNA. So now the DNA is going to be tested, but you know, our district attorney at first did not want to test DNA. And can you talk a little bit about why she would not want to test the DNA, and then tell us about the DNA testing anyway? Why is this going to be so important?
You know, the DNA is so important. I mean, we are, of course, very distraught and disturbed by the fact that the fingernail scrapings, again, have disappeared. That's a troubling fact. You know, initially, the district attorney general said that the fingernail clippings did exist, and now they don't, and they're not accounted for. So that's very disturbing to us. But why the DA initially opposed DNA testing, I can't explain that. It doesn't make any sense to me. You know, as our DA here in Davidson County said, if somebody's offering to test DNA for free, it'll be the policy of the Davidson County DA to always take them up on that offer. Why Shelby County didn't have that same policy, I can't explain that. But we are grateful to Judge Skane for allowing us this opportunity to have the DNA tested of what items of evidence do exist. Again, the most probative items have disappeared. The victim's clothing, the vaginal swabs, and the fingernail scrapings. So that's disappointing. But we do have other evidence. And what Judge Skane said in her order is, if we are able to establish, you know, a profile of a third person on multiple pieces of evidence that's not Purvis Payne, then there's a reasonable probability that the jury wouldn't have convicted him. And that goes against the narrative that the DA had been putting out, where she had said, you know, she called a press conference and said the evidence is overwhelming against Purvis Payne. There's no way that DNA could exonerate him. And the judge said, no, DNA could exonerate him if it's there, you know, and we don't know until we test. Right. So, you know, we asked to take immediate custody of the evidence, which was allowed. We went back and packaged it up immediately and walked it out of the courthouse straight to FedEx. And it is now at the lab in California, where it has been inventoried and shortly will be subjected to testing. So we'll see what we see.
Right. And how long do you think that will take to do that? I've been getting.
He said about 60 days. So we expect the result. Yeah, we expect the result middle of November, so shortly before Thanksgiving, which will be close. It's close to the execution date. There's no doubt about it. So
that's what I want to talk about next. I want to talk about that. I want to talk about what is it that you and your team, as well as and I know the Innocence Project is on this as well, and other people are looking at this as a case that, you know, that deserves to be looked at, that deserves to be talked about. I know some media folk are getting wind of this as well. So what is it that, because that is so close. So, well, let me ask this first before I ask what we can do. So like right before Thanksgiving, so if it comes back and there is a third person, that's what, because you're assuming if, you know, like Purvis said, that, you know, he was there, stood over trying to help. So you think that maybe he'll be there, but that third person. So if it's a third person, what's the next step for the team? And what do you do between Thanksgiving and December the 3rd?
Well, right. So we're not going to wait until the middle of November to request relief from the governor. So that's number one, but so put that aside. Mm-hmm. If we get an exonerating result shortly before Thanksgiving, then one would presume that we would get a stay of execution since we had evidence that he didn't do it. Right. You know, and that changes things obviously dramatically. because at that point you're not, listening to lawyers' arguments and trying to make inferences about the evidence that you see, but you have science that proves he didn't do it. And at that point, we would be, immediately back in court. We would be looking for an exoneration from the governor and immediate release if that were to be the case. But in the meantime, we are also asking the governor, or we haven't yet, but we will be in the beginning of October, asking the governor to commute his sentence based on this intellectual disability issue, because while we're waiting on the DNA evidence, there's issues of innocence in this case, but there's also the issue that he shouldn't be on death row. And those two things are not mutually exclusive. In fact, the intellectual disability is, why he's on death row, right? And when the U.S. Supreme Court said that it's unconstitutional to execute individuals who live with an intellectual disability, one of the reasons is because people with intellectual disability are at a heightened risk for wrongful conviction. And that's because they don't make good witnesses on the witness stand, which is certainly true here, and they're not able to assist their lawyers. And that's also true here. Because of Purvis's intellectual disability, he really couldn't advocate for himself. He really couldn't, be taken seriously, I guess, enough by the system or his lawyers, to prove himself. So, look, we know he's intellectually disabled. There's really no doubt about it. It was known when he was a child. He was born prematurely. And people have these stereotypes about what intellectual disability is supposed to be and what it's supposed to mean. But this was a young man who was loved and taken care of by his family. He still lived with his parents. He worked with his dad, painting houses. He was in the church. But he had an intellectual disability. And that's just the fact of the matter. And so as a legal matter, it violates the Constitution to execute someone with an intellectual disability. And in Purvis's case, what has happened is that claim was not presented until what the courts have said, too late. They've also said he's just too late for the procedure that we have, this is when people can get really annoyed at lawyers in the legal system, because it is about how many angels can dance on the head of a pin. But the Tennessee Supreme Court said, if Mr. Payne is intellectually disabled, then the state of Tennessee has no interest in his execution, which is correct because it's illegal. They also said that they urged the legislature to act, to create a procedure to basically patch this hole in our statutes in order to provide him the mechanism to be adjudicated intellectually disabled. So factually, we know he is, but he hasn't been able to be adjudicated intellectually disabled, and that's how the state of Tennessee could proceed to execute him unless the governor steps in and gives him, either a commutation of the sentence outright or at least a reprieve until the Tennessee Black Caucus for State Legislators is able to propose the bill that they have said they will propose on day one of the 112th General Assembly to provide a mechanism for Purvis and others. There's only a few who are in that same boat. But to go to court and to prove their case. And once we get into court, it's easy. It's not debated. The state has never quarreled or quibbled with our evidence, and our evidence is clear. We just need that opportunity, either in a court of law or for the governor to act and remove the death sentence from this equation. And then we'll continue on to fight to free him because he's innocent.
So when you were talking about commutation, can you just explain to us what that act is, if the governor decides to do that?
Certainly. So under the law in Tennessee, there's this broad category called the governor's clemency powers, right? So when someone says they're asking for clemency, they could be asking for a number of different things. And the Tennessee law actually gives the governor very broad powers, some of the broadest clemency powers of any state in the union, actually. When you ask for a sentencing commutation, that is to say, commute his sentence from death to life imprisonment. And that's what we would be asking for, because that is the only punishment allowed under the law because of his intellectual disability. So it would be, a life imprisonment sentence. Life without parole was not available at the time, so it would be a sentence of life with parole, which means he would have an opportunity of coming home if the parole board approved him to do so. And, in fact, Purvis has already served the equivalent of a life sentence, having been sentenced in 1988. I've represented a few people who were had their sentences reduced to life imprisonment who've since been released because of their positive prison behavior. So it would give Purvis an opportunity for hope. That's not the end of the story. We're going to make our case for innocence in our request to the governor, and we'll continue to press our evidence of innocence as long as there's a breath in my body and Purvis is alive, because I believe he didn't do this.
So, listen, I'm already on board, but listening to you, I want to get on board again and again. So, what is it that you are hoping and asking us as church leaders, as people of faith, as just the community in Memphis and Shelby County, but indeed all of Tennessee? What is it that we can begin to do now to assist your efforts in eventually, prayerfully bringing Purvis back home?
So we are asking folks to go to purvispain.org and sign up on the petition. We really need our numbers from Tennessee to go up, because we need the governor to understand that the people of Tennessee do not want Purvis to be executed, right? I mean, the governor represents the people. Purvis's execution would be in the name of the citizens of the state of Tennessee. So if the citizens of the state of Tennessee tell the governor, we don't want this to happen, then he's going to listen, or he should listen. And so that can be a very powerful way of getting involved. And when you sign up on purvispain.org, then you'll continue to get updates in the case. But that's not all we're asking. We're also asking folks to write letters of their own. So there's the petition to sign, but also to write a letter to the governor. Either send it through the governor's email address or send it directly to him. Handwritten letters are really powerful because it tells the governor that somebody sat down and took a minute to think about it, and they didn't have to just click a button. So we're asking that. We're asking folks to, say his name and spread the word on social media and through all of their networks. Not everybody's on social media. Some people, still talk on the phone. However you communicate in your neighborhood, in your circles, in your Sunday schools, in your worship services, with your coworkers, spreading the word about Purvis's case, letting people know about this injustice that is happening in their name right before our very eyes, and that they can do something to stop it by lifting up Purvis and his family through these letters, through signing the petition, through talking about it in your classes, having it part of your Bible study, just becoming a witness to what is happening, showing up at the corner of Union and McLean every Wednesday to hold up your sign and say, I stand with Purvis Payne and his family. And that really means so much to Purvis's family. I can't stress that enough. I've been through this process far too many times, and our clients' families are left feeling heartbroken and alone and not supported. And the support and the love that Rolanda and her dad Carl have received so far is such a blessing and a gift, and it feeds them, and strengthens them. Although Rolanda doesn't eat a lot, she's a pretty strong lady, but it just helps. It helps them to keep the fight and keep the faith. That family has so much strength. They've taught me about spirituality and Christianity in a whole new way. For them to have been able to get up every day and do what they do and stand by Purvis for 33 years, because, they've been in prison with him every step of the way, and yet they've never turned away from him. They've always stuck by him. And so we ask for that. We ask for prayers. We are hoping that we will be able to organize a day of prayer on October the 4th, which is the day before we will be giving our clemency petition to the governor. just, to pray for Purvis, his family, the governor, the victim's family. Our hearts go out to them. That there's nothing about this that is intended to cause pain to Sharice Christopher's family.
Right.
But justice doesn't come through the execution of an innocent man. And justice doesn't come through the execution of a man who's not eligible to be executed.
Right.
And so, we're asking a lot. And we're also asking for ideas, we don't have all the answers. So other ideas that people have about ways to get involved, we're all ears.
Wow. I tell you, this is, I know you've been doing this, like you said, since '88, and you have been and I'm sure you have just been a blessing to the Payne family and to all of your clients, and the hard work and the efforts that you put into doing this work. I've always been, just a little bit about me, I've always been anti-death penalty. One of the reasons why we are on Union and McLean is for 15 years. I think we stopped, the anti-death penalty advocates used to stand on that street corner every Wednesday at the same time. And when I called Dr. Pete Gacky at the Memphis Theological Seminary, I asked him, I said, are the anti-death penalty folks still standing? Because I stood with them for several different times as well. He said, no. I said, well, I think we need to get that back started. I'm going to call an action and do this. So I've always been, but it was only when I really began to work with Erskine Johnson, brother in Dume, that was, I'm sure you're familiar with him as well, who was on death row. His lawyer, Anne Marie Moyes, reached out and I got involved again. We were going, I remember going, trying to find witnesses, looking through different places and spaces, trying to talk to churches, trying to get, and, good for him and good for her that, things eventually, I think in 2012, if I'm not mistaken, he was released. Right. Yeah. And so, again, another egregious case when he was at a party and a bunch of witnesses like, dude was here with us and you're talking about not being believed. And this whole thing that I try to teach about sometimes called Black truth, where Black truth is just not believed or it's not held up in high esteem as anybody else's truth. So it's when I visited him and just, on death row, and when those bars slammed, when I was walking out, it was just like, oh my God, I need, even more. So I guess what I'm trying to say, when I was reached to do this, I didn't have to be sold. I was already here and I just needed to know, what do you want me to do? And when you said something about ideas, I said, well, I got one. I can do this. And this is what I am trying to share with our listeners and viewers today. Attorney Henry has already, if you were listening early on, she said that she feels called or felt called to this work. I know I feel called to this work that I do. And I know others out there, you feeling called, but you just don't know what to do, or you kind of like, I don't want to get out there what they're going to say, what people are going to say or do. I am praying for you right now, for your courage. And I'm praying for you that you will find something inside of you to meet us on Wednesdays, or to sign the petition, or to sign the letter, or write a letter yourself. We're going to start a writing letter campaign, and we're going to try to do one each and every week up until the supposed, and I always put that in quotation, my supposed execution date. We want to be a part of this because this is what it means to be a person of faith, to stand with those on the margins of society, to stand with those. Matter of fact, for Christians, it is one of the ways we're supposed to get to the kingdom of God. I was in prison. You came to visit me. I was hungry. You gave me food. Those little things, that little scripture, that's in red. in a lot of your Bibles. So you better read that one. So I just want to say thank you again for being a part of this conversation. And you have done my heart well. I know you bless other hearts as well. And it is good to know that there are some attorneys out here that are really fighting for those on the margins. And it is just, I don't know, just to say thank you is just not enough. But, just to accept your call and to do it and to reach out and to say, hey, you can help me in this way, that's important. So thank you again, Attorney Henry, for doing all that you do. And may God continue to bless you and lift you with God's love and grab you with God's grace. And may you be always present in the divine.
Thank you so much. I really, really appreciate this opportunity and all that you are doing. Together, when we bear witness,
Yes.
we can have the truth be heard, even by people who don't want to hear it.
That's right.
And they don't want to hear Black truth, but we're going to make them listen.
And as we say in the church, amen and thank God. Thank you.
Thank you.